obviously, Zac got a release from Parramatta from a multi-year deal to pursue opportunities with R360, which was a upstart rugby competition that eventually fell through. Now, what played out in the Supreme Court is that Zac sought to challenge the settlement deed that he had with the Eels, which restrained him from competing with the rival NRL club without their written consent. Now, Callum, with your great experience in employment law, what's the purpose of a restraint of trade?
So a restraint of trade provision in an employment contract is a way of a company protecting their legitimate business interests. So that's restricting an employee from going into direct competition with them. So in Australian law, generally restraint of trade provisions are unenforceable due to public policy reasons unless they can prove that their legitimate business interests will be harmed.
And how does this relate in a sporting context?
Well, I think it relates the same as any employment contract. In sporting employment contracts with elite athletes, they will have, more often than not, they'll have restraint of trade provisions. In the NRL, they have something usually called a non-rival stipulation, which prevents players from playing for direct competition, either other teams, whether that's before the end of their contract term or during an early release, as we've seen with Zac Lomax.
Now, I understand the parties agreed by consent, so it wasn't necessarily a final judgment given by a judge. So what resulted, and was the restraint upheld?
Yeah, so it was upheld, albeit the restraint was reduced by 1 year by the New South Wales Supreme Court. I think it's important to note that the parties went into a deed of release, which is a heavy-duty contract, usually referred to as a contract under seal, and that had a big part to play in the consideration given to the situation by the New South Wales Supreme Court. It put Parramatta Eels in a strong equitable position. And from there, the consideration that the New South Wales Supreme Court would have seen was that it was freely negotiated by both parties who were legally represented, which is an extremely important part of the argument that Parramatta Eels put forward. So that put the Parramatta Eels in a strong equitable position. The deed itself showed that both parties freely negotiated and were both legally represented. It meant that any sort of argument from Zac Lomax that there was a change of circumstance kind of fell by the wayside, because the doctrine of restoration is difficult in itself, but under a deed it's almost impossible. So certainly the deed has something to do with it, but also the general common law concepts of restraint of trade, i.e. was Zac Lomax the face of the business? He certainly was. He's one of their marquee players who has international experience and New South Wales state experience. So he certainly was one of the most important players, and to be able to say that he was moving over to the Storm, who are definitely up there as one of the best teams in the comp, was definitely showing that their legitimate business interests would definitely have been harmed.
I guess on that point, and obviously now that he's restrained until 2027, the non-compete clause itself, is it harsh or just good business?
It's definitely not harsh at all. I personally think it's very smart business, because you have a player of Lomax's caliber sitting on $700K a year. It's definitely on the high end of salaries in the NRL. So when he's coming to the Eels and saying that he wants to come out, they're not just going to look at him and say, there's the door, goodbye. They're going to put mechanisms in place that will ensure that he stays within that time of his contract. And that's what good businesses do at the end of the day. So some people say he should be able to transfer, go wherever he wants, let him go, because he's a player at the end of the day, he's got a big name, he's a marquee signing. Even the Supreme Court held this because they saw it as it wasn't Parramatta overreaching for their requests. So these things are in place to ensure that a player can't just enter into something and then just leave whenever they want to. That's why there's draft provisions in place. That's why there's negotiations happen prior to it being signed to prevent them from just exiting whenever they want to.
Obviously, there would have been a massive cascading effect should Parramatta have wilted on this. I can imagine they would have been under a lot of pressure from internal stakeholders, external. Obviously, allegedly, Parramatta sought help from the NRL in putting the pressure on them. How did they manage to hold it all together through this whole process?
That's something that doesn't get talked about enough. And to give credit where credit's due, and it burns me as a Bulldog fan, but you have to give Beach and Sarantino their credit. They were able to manage their fiduciary duties responsibly and in a caliber that sets the precedent for the entire NRL and the other CEOs. Because ultimately what they did was they maintained a uniform understanding within the club to ensure that any sort of communication that was taken outwards was relayed in a manner that maintained Parramatta's reputation in a very high capacity. Where you had the RLPA publicly criticising them, you had Melbourne Storm trying to poach their players, you had the media putting articles out every single day. And these things naturally would make an organization crumble. But Para didn't flinch at all. So they've set a very good precedent for the NRL to say that when restraints of trade are being pushed and questioned, they have to take a unified stance. They even got players like Mitchell Moses to come out and just speak the same words as the board ultimately, which gives confidence not only internally within the club, but also cohesively to the fan base, which shows that they're also taking stewardship very, very importantly.
I guess on that point, it seems like it's bigger than Lomax in itself. And whilst he is the one held to account, there is a much bigger implication of this for the code in general. So what more is there to this?
Yeah, so in the interim, it was just Lomax, but after it, way greater than Lomax. By Para not budging on their stance, they have set the new precedent, as I mentioned before, for the NRL, where if they fell and they cascaded down, then football agents would have seen this as an opportunity to cause a ruckus whenever there was an issue with restraints of trade for their players. Now, they now know they cannot walk over these lines. The Supreme Court upheld this, and Parramatta made it very sure. And to the point of the entire NRL, the CEOs in their meetings have given Parramatta praiseworthy comments on this because they've been able to maintain a very strong approach, which will now, looking forward, be the bare minimum within the NRL.
So you mentioned the risk of agents, had this gone through and Lomax was allowed to play, the risk of agents feeling like they can act by themselves. Obviously, there's the RLPA, which you also mentioned before, and the idea of a union is to represent the body as a collective, and in that collective body, you have more bargaining power. Mm-hmm. So I understand the risk of having individual-based agreements like this upheld kind of undermines the importance of the union. Now, what's the point having a union if individuals can go off and negotiate their own bespoke agreements?
Well, the collective bargaining agreement exists as a framework and baseline protection for players and their clubs. So going to your point where you said, what's the point of having unions there? I totally agree with you, because when Lomax in this circumstance is negotiating a bespoke release deed, then what's the purpose of a union? Because when it went all hellfire, he came to the union and said, where were you guys? And they weren't even at the table when they started the negotiations and the agreement in the first place. So the bigger question is, should these arrangements sit within the collective bargaining agreements moving forward? And if players keep on bypassing this, what's the purpose of the union being there ultimately?
I guess obviously it places a high level of importance and probably the fiduciary duty on the agent itself. Obviously they're at arm's length, but they can't make the decision. But obviously there's the importance of them advising the players accordingly. Now, Callum, noting Lomax is now signed with the Western Force in Rugby Union on a multi-year deal and Rugby Australia, what should athletes and sporting organisations learn from this whole saga?
Yeah, I think there's three main takeaways for sporting organisations and athletes as well. The first is that any instrument used to document these agreements, it matters enormously. For sporting organisations, I think moving forward in regards to agreements with early releases, they should be requesting that these are put into deeds of release. It puts them, like I said, with the Parramatta Eels into a strong equitable position. And for players, they need to understand what they're getting themselves into when they're signing these deeds. Due to the fact they're heavy duty contracts, they need to understand that they can't just step out of it whenever they want due to a change of circumstance. Secondly, conditions attached to these early releases are restraint of trades, and they should be treated as such. With sporting organisations, they need to make sure that the restraint is tailored, proportionate and defensible. And for athletes, they need to be able to know exactly what they're getting themselves into in terms of asking questions to their legal representatives and agents. And then thirdly, the conduct in those negotiations may directly impact any subsequent legal proceedings. So for sporting organisations, they need to be documenting throughout the chronology process of the negotiations. And then for players, they need to come away with clean hands. So their conduct throughout those negotiations is really important. So in Zac Lomax's case, discussions and correspondence with Melbourne Storm and their correspondence with thus the NRL, which was subpoenaed by Parramatta, that needs to be avoided.
It does seem that it can't be understated, the power and the relevance of strong advice and advocacy for all players. And so obviously this is probably a cautionary tale for players, because 2 years on the sidelines, or what was a few months for Lomax, is essentially dog years for a player's career. And so hopefully going forward, similar instances don't happen and at least players are well informed.